Welcome to Case by Case. This is a podcast brought to you by Luke and Calum Chain of ZFZ. How are you, Calum?
I'm good. How are you doing?
Good. Good to be on again. I know we mentioned last time that we're going to be catching up in person for a live episode of, a summary of Case by Case, but we've managed to squeeze in another one before we catch up in New York and present to our clients.
There have been a couple of interesting kind of shippy commodities cases recently. The one we did last week and this one, both kind of looking at scrutinizing the language of bills of lading. Both from the Courts of Appeal. It's a purple patch for these kinds of cases.
Yeah, and we've got Lord Justice Males who's written up the leading judgment here. We had Lord Justice Popperwell, who's also on this Court of Appeal decision as well, although in agreement with Males, and he wrote the last one that we dealt with. So we got some of our favourites churning out the judgments for us.
This is a good one. Really interesting look at a distinction between the Hague and Hague-Visby rules with respect to what the time bar covers. I was fascinated reading this. There were points around the difference between the Hague and Hague-Visby rules that I have to say I hadn't appreciated the importance of some of the subtle differences between the two regimes.
Yeah, I'm the same as you. I was going to confess to not having looked at this particular point in as much detail as is traversed in this judgment, and it made for fascinating reading because we look at in this decision two conventions. Well, one an amendment of the prior convention, international conventions, and as we know that has a whole kind of body of law around how you do that, how you interpret an international convention. It's not exactly the same as a statute, a national statute. There's some intricacies involved in that, and it always requires a look back at, the travaux préparatoires, the history of the cases and how this has been looked at also in different courts around the world. So a really fascinating topic and one to get into today.
It's a good one. And so the question on this appeal is whether the 1 year time limit in the Hague-Visby rules applies to a misdelivery which has taken place after discharge. So if you imagine a timeline, and in that timeline you have, I suppose, the contracts to ship the goods being agreed at the very start, and at the very end you have the delivery of the goods to somebody. There's a part of that timeline, the kind of middle block, starting with loading and ending with discharge, which is the period of ocean carriage. And the question is, if there's a misdelivery outside of the period of ocean carriage, i.e. that latest point in the time bar is not where your ocean carriage ends. There's a discharge from the vessel, but it's held somewhere before it's ultimately delivered to somebody. If that delivery is wrongful and therefore a breach, but it happened, but the claim is brought outside of the 1 year time bar provided for in the Hague-Visby rules, does the time bar bite?
Yeah. It's one that I would have just instinctively said yes to, I think. If someone had asked me, I said, yeah, there's definitely preserved time within the 1 year. But yeah, there's much more to it than that instinctive response, albeit that is the ultimate response here. Giving a game away, for which we often do, spoiler alert and all that. But just before we get into it, and I don't think we need to go into too much detail on the facts, because in many ways, what you've just identified is really the factual background to this. And it's more about interpreting the international conventions. But the decision we're looking at for our citation lovers out there is FIMBank PLC and KCH Shipping, relating to the vessel, the Giant Ace, which is where we get the title for this podcast episode from. It was delivered on the 24th of May, 2023. And as I said, we have Lord Justice Males, Lord Justice Popperwell, and Lord Justice Nugi on this court. Neutral citation number is 2023 EWCA Civ 569. So we're up into the English Court of Appeal here. It was an appeal from Sir William Blair, and it was an appeal to the commercial court from an arbitration panel. And it was actually quite a senior, esteemed LMAA arbitration panel as well, comprising Julia Diaz QC, Sir Bernard Eder, and Tim Young KC. We don't often identify the arbitrators on this, but I think they'd be happy for us to do so here because they've had both the commercial court agree with them and now the Court of Appeal agree with them on this question. So
this is an interesting one because it's gone all the way up, but no one has found anything other than that the time bar applies. So it feels like its appealability, if you like, is based on how a kind of interesting point this is, and it's a point of general application on the Hague-Visby rules, which are as the listeners will know, which are incorporated in a large number of bills and charter parties, and it seems like this one's being is able to be appealed through the system because it is that kind of public importance, or it's a case of public importance rather than necessarily a case where there's been some kind of error by the tribunal.
Yeah, and you're right. I totally agree with you, Calum, for not the first time. But also I think it's an opportunity, isn't it, for the senior courts in England to make a statement on this issue, because there have been other courts around the world that have dealt with it, but it hasn't really been dealt with clearly, there hasn't been the opportunity to deal with it as clearly as the courts do here on this particular issue. And as you say, it also involves making a statement on what is the quintessential international convention here on cargo damage claims in shipping. So yeah, okay. Well, should we identify some of the brief facts here on this one?
I mean, really, the facts you need to know is that there was a claim brought after 1 year from discharge, and the owner turned around and said the claim is time barred. The nature of the claim itself is not really important in this one, but it relates to an action for misdelivery, and the court doesn't look in any detail at the underlying claim or the merits or demerits of that claim. It's laser focused on this question of, does the time bar apply? I think probably the key background point to set out is that discharge and delivery are two distinct concepts. It's not uncommon for them to occur at the same time when you discharge immediately off the ship into the hands of the holder of the bill or whoever you're instructed to discharge to. That does happen reasonably regularly. However, they are two separate concepts, and we've seen we've seen in our work a number of times where this issue has been pretty important, and you have somebody alleging that delivery has taken place at point A in time, but in fact delivery only takes place at point B in time. And here the 2 points where the split between discharge and delivery was caused by discharge into customs bonded warehouses, and the cargo stayed in those customs bonded warehouses until collected by somebody who had to show that they had title to the goods. The trade finance bank here, FIMBank, alleged that the person that collected the goods did not have the right to collect them, and therefore the goods should have been retained for FIMBank, who were the holders of the bills. So I think that's the first point to make clear, is that in this situation discharge happened and then later there was delivery. And the reason that's important is because what the Hague and Hague-Visby rules cover is the period of the ocean carriage. So what we're looking at doing here by saying that the time bar covers a misdelivery even after discharge is we're basically saying the scope of these rules is extended for the time bar. So, most of the rules cover this period of ocean carriage, which ends on discharge, but actually the time bar is broad enough to still exist even after the ocean carriage is completed, and something goes wrong in connection with the carriage of the goods, but it goes wrong on land.
Yeah, exactly. That was the one point I was going to raise too on the facts, that there is this concept, there is this distinction between the concept of discharge and the concept of delivery. But here, in a way, it doesn't really matter, because both discharge and delivery happened well after 1 year on any view. You can imagine there are cases where there could be a debate about, the cargo gets discharged and then the time bar, the 1 year kind of falls before 1 year after delivery. And, you might be in a case where there's some kind of, where it's important on when the 1 year runs. But that's not this case. There was no doubt that it was well after a year following delivery, because of course the 1 year time bar references delivery of the goods. And what we're exploring today is this concept of the application of the Hague and the Hague-Visby rules, and that refers to loading and discharge. So you've got this kind of interplay between these two concepts, but in many respects, it's not pivotal in this case. Okay, good. So I think where we kind of go from here is really to set out the provision we're dealing with in the Hague and Hague-Visby rules. And that is looking at their application and what is the period of responsibility under the Hague rules and the period of responsibility under the Hague-Visby rules. And lo and behold, they're not the same.
The language has changed for a number of reasons between the Hague and Hague-Visby rules, but the time bar itself is Article 3, Rule 6 of the Hague rules, and it reads, "In any event, the carrier and the ship shall be discharged from all liability in respect of loss or damage unless suit is brought within 1 year after delivery of the goods or the date when the goods should have been delivered." And the key words there to bear in mind are, the carrier and the ship shall be discharged from all liability in respect of loss or damage. And that changes in the Hague-Visby rules. And that key kind of wording, all liability in respect of loss or damage, changes to from all liability whatsoever in respect of the goods. So there's this intentional broadening of what the time bar is covering. And the way that Lord Justice Males approaches this in the judgment is to look at the Hague rules first. And effectively, the way the judgment is set out is to say, this is the position under the Hague rules, and this position was intentionally expanded in the Hague-Visby rules. And in order for that expansion to be of any effect, it requires that the scope of the time bar is increased to cover this kind of land-based misdelivery after the ocean carriage part of the the ocean part of the carriage has been completed.
Lord Justice Males does that by going through the Hague rules in quite some detail and how they have been applied around the world in various cases, and that it's it's quite clear when you go through and look at the cases that I'm not sure if it's quite a consensus view, but the overwhelming majority is that the Hague rules were more narrowly drafted, such that they cover the period from, the sea carriage, as you say, from loading to discharge, and that the time bar under the Hague rules would not apply to a misdelivery claim arising outside of that period. And so the court actually spends quite a lot of time going through saying, the Hague rules, if this were a case arising under the Hague rules, the time bar would not have applied because the period of responsibility didn't include when this claim arose. And there's, as I say, there's lots of cases. I'm not sure if we need to go through them all now, but having gone through that kind of process, there's almost a fork in the road for the court. Do we now say that, well, with the Hague-Visby amendments or the Visby amendments, that position under the Hague rules has been maintained, and that and that as the bank were arguing that, look at all the body of judicial or jurisprudence on this issue that shows that the Hague rules should not be applying, and the time bar should not be applying to these types of claims outside of the period of responsibility. That's one kind of way that the court could have gone. The other one is to say, well, actually, no, the Hague Visby rules have a deliberate departure from the period of responsibility under the old Hague rules, particularly with respect to the time bar provision. And that's what Calum's kind of referring to, this difference in language. And yeah, as we've said, the court goes the latter of those routes for a number of reasons.
The start of this judgment, actually a large portion of this judgment, is devoted to looking at the Hague rules to sort of set the base position, I suppose, under the initial, under the Hague rules before they were amended to become the Hague Visby rules. And the finding is that, as you say, Luke, one, if this situation were to be played out under the Hague rules, the position would be that they do not apply to a misdelivery that happens on land after discharge, because that's outside of the period of responsibility of the that's outside of the period of ocean carriage, and therefore falls outside of the Hague rules. The second point they look at is taking that wording that I mentioned before, all liability in respect of loss or damage. How broad is that, and is that broad enough of itself to include a misdelivery that happens at the same time as delivery? So if there's a misdelivery which happens within the period where the Hague rules apply, is the wording for the time bar broad enough to include that misdelivery? And the answer to that they found was yes. Yes being the wording in Article 3, Rule 6 of the Hague rules, that it covers all, that the time bar is in respect of all liability in respect of loss or damage to the goods. That's broad enough to include a misdelivery claim. However, the misdelivery claim will only fall within that time bar if it is if misdelivery is at the same time as discharge. If it's later, then because of the way the Hague rules are drafted, the period within which they operate has ended on discharge, and therefore the time bar won't apply because the Hague rules won't apply. So you have those two findings, and then the court says, okay, but they've broadened the language in the Hague Visby rules. So if they're broadening the language, they're going from this already extremely broad clause where the type of loss which is covered is extremely broad, even if the period within which this time bar applies is narrow. And they're saying that's being broadened. And if you can't sensibly broaden what the clause is intended to apply to, i.e. the breadth of the clause, this would already apply to a misdelivery action, but they've made it more broad. What could the broadening be intended to cover? And the answer that the court says is this situation. The intention of the even more broad language in the Hague Visby rules is to make sure that it covers misdelivery, but include and that's to include misdelivery which happens after discharge.
Yeah, exactly. And to arrive at that position, the court looks at some of this fancy French word, the travaux préparatoires, which I'm sure you can pronounce better than I can, Calum, which are basically the preliminary papers to an international convention, which might include some of the debates or the commentary that the subcommittee that had been drafting the convention, shares with the world on these issues, and they can have some persuasive effect in, indicating what were some of the issues at play. But there's also a little caution, I think, in looking at these papers, because they are not the convention. The convention is to be interpreted on the words that are in the actual instrument, and international conventions, by their very design, are areas of compromise. There are a lot of parties, both national parties, lobby groups within nations that put input into the subcommittees, and that can come out in the travaux. But the international convention itself is what's signed off. And so you need to kind of look at, well, what was the debate that's being had, without saying, okay, this is what they meant, and you can see that because that was what was being debated before. Well, no, I think it goes more to what were some of the issues in play? Were they considering these types of issues? And then you say, well, what was the language of the convention that was landed upon? And then we interpret that language within the context of the debate. And so there's some nuance in all that, and we could talk for quite a long time on the rules of construction in interpreting international conventions. But I think here it's good to identify that, because there was a debate that preceded the Visby amendments that went to what should be the scope of the Hague-Visby rules, and what indeed should be the scope of this particular provision. And then it was expanded, right? And so that's why you have the court here, explaining that this was there was a debate on this, and then looking quite closely at what were the changes. And I think if you look at paragraph 70, Calum, I think this is really the crux of it, and I might just read this out, actually. The change from, quote, all liability in respect of loss or damage, close quote, to, quote, all liability whatsoever in respect of the goods, close quote, weakens or even removes the nexus with loss or damage to the cargo which was previously required. The word whatsoever is not merely emphasis, although it is that, but indicates the absence of any limit on the term which it qualifies, here, all liability. Unless the new rule applies in cases where the original rule did not, therefore the amendment achieves nothing. That is not a conclusion which should be reached lightly. So there's, in other words, there's very deliberate language that's used here. It clearly widens the scope of the clause and how it should apply. The question then is, how wide, does it extend to this kind of situation? And as the court says here, I think this is a quote from Lord Justice Bingham in the Captain Gregos. I do not see how any draftsman could use more emphatic language. It is even more emphatic than the language Lord Wilberforce considered all-embracing in the New York Star.
You have this all-embracing language which is made even more all-embracing, all-embracing, or all-embracinger. And the interesting thing around the travaux préparatoires, I think I've done that as badly as you managed in the end. The rule around looking to that body of I guess negotiations is that you have to have this direct hit, this bullseye, as they called it in one of the cases. And if you get the bullseye, then you can look at the travaux and you can say, yes, this has it's clear from the travaux why the clause is drafted the way that it is. And you can use that as you can use that to make an argument. If it's not entirely clear, if you don't hit that bullseye, then you can't rely on what the travaux say. And where I found this case gets quite interesting is around whether or not really we have a direct hit on what the travaux actually intended with this provision. And there's a really good summary of the Hague-Visby rules by Mr. Anthony Diamond, QC, in a 1978 paper, which was then quoted in the case called the Al-Hani. And it basically takes you through the history and the intention. Basically, they recognized when they were going through the Hague-Visby amendments that there was uncertainty in the phrase "all liability in respect of loss or damage to goods." There was uncertainty as to whether that would apply to misdelivery. And there was this original proposal that you would have a 2-year time bar for any missed delivery claim, which would be expressly included, and you would then have a 1-year time bar for loss or damage to goods. The committee then responded to that and said, well, we're not actually sure whether the time bar should be applying at all to missed delivery claims. We're not sure whether they should be covered at all under the Hague-Visby rules or under the Hague rules. And they debated whether or not it should. They decided, yes, it should, and we should just have one time bar for everything. And then they used the drafting and broadened it to make sure that it very clearly included missed delivery claims. And that's what the travaux préparatoires say. My question is that actually a direct hit on the question of, is the intention that the Hague-Visby rules time bar is extended beyond the period of ocean carriage? It's certainly a direct hit on the question of, does the time bar apply to missed delivery claims? But that's not what the judgment's about. The judgment's about, does it apply to missed delivery claims where the missed delivery has happened outside of the or after the period of the ocean carriage? And yeah, so in my view, it's not quite a bullseye. It's almost a bullseye, but not quite one. What gets it home, it seems, because this is unsurprisingly the point which is made against that argument that it's not a bullseye, is that at the time when the Hague-Visby rules were being drafted, the majority of cargoes would be delivered at some point after discharge. That was the ordinary course of commerce at the time. It would be unusual to discharge immediately into the hands of the person you were delivering to. And the Lord Justice Mayles says, therefore, when the parties were negotiating, and as documented in the travaux préparatoires, the understanding was that by very clearly extending the scope of the time bar to missed delivery, it was almost implicit that would also have to apply to missed delivery that happened after discharge. And for that reason, it's therefore considered to be a bullseye, and therefore you look to what they were trying to do. Okay, the purpose of this wording is to include missed delivery claims, and therefore it follows that it will include missed delivery claims that happen after discharge.
It's a really interesting point, Calum, isn't it? Maybe the title for this should be, is it a bullseye? The question on this pod, because you're right to identify it, and the court, when dealing with that particular issue, as you say, it actually falls back on a kind of custom of the trade or how things just are in practice, more so than a legal interpretation, if that makes sense. It's almost like, well, if it applies to misdelivery claims, then because a lot of cargo is delivered after discharge, and it's quite common that delivery occurs at a later point in time, then it must have been so that the drafters considered that those types of misdelivery claims are included, and there's no good reason to exclude claims arising after discharge, from land, as we had here, from a warehouse or what have you. It's not rooted in a really strong legal thesis, if you like, on that particular point. And if you're looking around, scratching around to say, well, where's the appeal point? Where do we take this further? If we want to try and, if we were on the bank's side trying to look at, well, could this go up to the Supreme Court? I think that is the area where you'd try and look at it some more to say, well, how solid is that distinction? Now, I do see the contrary argument, I've got to say, that would it be likely that the drafters of the Hague-Visby rules had in mind that those types of claims arising after discharge are not included within the time bar, and there's some kind of hiving off of those claims arriving later on? I don't know. I can see why the court's given it quite short shrift, but that is a key issue here, right?
Totally agree. I think it is, because it throws into question why there's a need for a distinction between this and the Hague Rules. And the rationale for that appears to be a legal principle that you should try and give effect to something being changed. There's a reason why something has changed. But if the reason that it's changed, so the courts have come to the view that the Hague Rules cover a misdelivery action, but it's clear, or it's unclear on a first read of the Hague Rules whether they actually do. That's an open point. When you read the words, this is a time bar that applies to all liability from loss or damage to the cargo. There's an open question as to whether or not that includes misdelivery. The Hague-Visby rules then remove that. They remove that ambiguity. They say, we want to make this really clear that the intention of these rules is to cover all claims, including a misdelivery claim. So we're going to change the wording to, make sure I get it right, to all liability whatsoever in respect of the goods. If that's the intention of the change, then it doesn't necessarily speak to an intention to extend the period of responsibility, or extend the period that's governed by this time bar beyond discharge. There's no mention of that in their discussions. There's no reason why necessarily that should be the distinction between the Hague Rules and the Hague-Visby Rules, when that point wasn't aired in these discussions. Do you kind of see where I'm going with that?
Yeah, I totally see your point.
And I think there's scope to. I'd be interested. The more I think about it, the more I think, why should it be different? The position between the Hague Rules and the Hague-Visby Rules, if you have wording which is unclear in the Hague Rules, but over time the courts come to the decision, okay, this is intended to cover misdelivery, but not misdelivery after discharge. And then you have wording which is specifically designed to make it clear that it covers misdelivery. I don't think it necessarily follows as a bullseye on the Trevor Preparatoire there. I don't know if it necessarily follows. that was a bad one. Yeah, but I don't know if it necessarily follows that you have this extension of the period beyond discharge. I actually don't quite see it.
Yeah, but was there a change in the language for the period of responsibility between the two? That's what I was just going back to look at.
I don't think so. It certainly isn't something which is discussed. And another interesting point, just while you're looking at that, is that in Hong Kong, they take the opposite view. In Hong Kong, they say that the Hague-Visby rules don't apply for a misdelivery occurring after discharge, and there are two case authorities for that. But they didn't go as far in Lord Justice Mayall's view as demonstrating an international consensus. One thing that I did think was quite funny was when Lord Justice Mayall went through the textbooks and basically managed to land on textbooks that were drafted by, or at least had on the editing panel, each one of the arbitrators, which it kind of shows the serious thought that's gone into this from really preeminent arbitrators and justices.
Yeah, look, I'd have to go back and look. I'm not stumbling upon it quickly enough, but I think that's the the wedge here. I think that's the rub of it, where if you wanted to look some more at this issue, and as we said at the outset, 3 highly esteemed arbitrators ruled one way, Court of First Instance ruled one way, 3 Court of Appeal justices have all ruled the same way, and I think the decision makes sense. I really do, but there is that little bit at the end there, which I think if you wanted to try and write a paper on this, and kind of really look into it some more, that would be the opening, I think, for some more analysis.
I agree with that, and who knows? I don't know if this one is appealed, or whether it will be appealed, or whether it's going up. It's a recent case. We're recording this in very early June, and this judgment was handed down on the 24th of May. So who knows? Remains to be seen. In a way, I wouldn't be surprised to see the Supreme Court take a view on this one, and I hope they do.
I would be surprised if this goes up as well. It's such a kind of broad issue on an international convention with courts around the world commenting on this or parts of it, or related issues. So yeah, wouldn't be surprised. Wouldn't be surprised at all if this one comes back before case by case.
Excellent.
I think I'm done on this one. I think we've kicked it around enough. There were some other points in there. The owners wanted to have an alternative argument on implying a term. The court said, forget it. That's not going to fly. This is in any event, they didn't need it because they won on the primary point in interpreting the convention. But it's worth noting in passing that implied term arguments regularly fail. They're tricky to make out. And here, you can have implied terms as a matter of fact or as a matter of law. There was nothing kind of in the facts, and this case really wasn't argued on the facts through the award or into the court. So it wasn't. You weren't going to get an implied term on the facts. So you're looking at an implied term at law, and the court's like, well, no, this is not the kind of situation where you would be implying a blanket term across these types of cases on every case. This is more a situation for interpreting the convention, and that's it. And I think there was another final point, but that also got. There was a debate about whether Clause 2C could have the effect of disapplying the time bar in Article 3, Rule 6, the time bar, and that also was given pretty short shrift. So. There we are. Thank you for listening in. We hope you found this interesting. It's yet another recent decision on delivery in the shipping space. We hope you're enjoying these podcast episodes. If you do, please do subscribe. Please do follow us on the various channels you listen to this on, whether it's on Spotify, YouTube, Apple, or Google Podcasts. It does help build the profile for the podcast, and also gets it dropped straight into your feed on those podcast channels. So thanks for listening in. Until next time, take care. And as always, Calum, good to catch up.
Cheers, everybody. Bye.